Yes, Mr. Doherty.
Well, before the short adjournment, I'd taken your lordships to various commentaries made by Professor Briggs. There are also comments to be found from Professor Mitchell and Professor Stevens. I don't intend to take your lordships to those. They're referred to in the written case. I can give your lordships the reference again. It's 1304 and 1329 for Professor Mitchell and 1338 for Professor Stevens. But essentially, I mean, the point, but briefly, but it again doubts the question, the construction of the statute reached by the court in Hashim and/or regards the conclusion as unprincipled. So the references are there, and the main analysis is that really set out by Professor Briggs. Now, before I move on, I was just going to give your lordships one reference arising out of a question before the short adjournment in relation to the relevance of a pre-existing relationship to the question of what should be the appropriate law of contribution. And the reference I give your lordships is page 1101, which is an extract from Dicey, the 14th edition, because the new edition, post-Rome II, deals with this in much more briefly. And it's paragraph 34051. And
beg your pardon, I haven't got the page.
Sorry, my lord, it's 1101.
Thank you.
And it's 3451. And Lord, just the relevant passage, it deals with claims for contribution and deals with what the principle ought to be, in particular that it should be the law with which it is most closely connected. But for these purposes, the bit I want to take your lordships to, it starts in the middle. In the identification of this law, the law which will be applied to the original liability and tort may be relevant, but it is not decisive. A similar approach should be taken to claims for contribution between partners, trustees and sureties. In cases where there is a pre-existing relationship between claimant and respondent, whether contractual or otherwise, it is submitted that little or no weight should be attached to the place of enrichment, and that in other cases its role should not be dominant. It is only with difficulty that discharge of a respondent's debt to another, which may be the foundation for the claim and contribution, may be ascribed a location. And then it refers to the conclusion in Hashim in the final sentence. My Lord, can I turn relatively briefly to deal with the other cases that my learned friend relies on in support of his submissions, in particular the Bonati, the Capitan Georgis, and the Baltic Flame. Lord, in short, we say those decisions are of no assistance to the question before your lordships. It's common ground that the question of overriding effect and the applicability of the 1978 Act pursuant to the applicable law was not an issue, let alone argued. The Bonati was a strikeout case. The Capitan Georgis and the Baltic Flame were jurisdiction cases. In other words, there was no need to reach any conclusion or final conclusion on the question of applicable law. And in none of the cases did the court, in fact, address the question of overriding effect, which, of course, is unsurprising, given that it wasn't argued or an issue. So, Lord, our short submission is they really don't provide any benefit, and seeking to dissect statements made in those statements which are devoid of the relevant context does not assist. And in that regard, we say the Court of Appeal were entirely right not to find those cases of any assistance. My learned friend makes a slightly broader point, which is to say, and this is his nodding Homer's point, that, namely, if it was a good point that the 1978 Act was subject to the applicable law, then it's inexplicable that such a cohort of eminent practitioners and judges could have failed to spot the point. So, recognising that the point's not taken, but nevertheless saying that it's simply inconceivable that if it had been a good point, it wouldn't have been raised there. Now, my Lord, one questions where that takes you when one's already got to this court, but it's not with respect a good point anyway. The first point to note is one that I've made before, which is that you only run foreign law points, including questions of the applicable law of contribution, if one thinks it will have a material effect on the case, if it will help. As I've already indicated, in this case, the only relevant difference which was identified in the pleadings is the question of limitation. If there hadn't been an issue of limitation, there would have been no reason to raise the question of applicable law. In most cases, or most issues, that the point is unlikely to make a difference. Second, that point is all the more so when one considers the context of those cases, which is that they were strikeout or jurisdiction disputes. The effect of the fact that they were strikeout or jurisdiction disputes meant that it was to run the point effectively, it would have been necessary to show first that it was not arguable that English law applied. There was no serious issue that English law applied, i.e. so plain that it couldn't be English law, the serious issue aspect. And secondly, that under the foreign applicable law, applicable contribution law, there could in fact be no contribution. It wouldn't have been good enough to say it would have been in a better or a worse position. It would have to have been, for the purpose of strikeout or a jurisdictional point, to say that there was no contribution at all, which of course would have required evidence. So Lord, one sees there why, first, these points simply will often not arise, or be points that can be taken at a strikeout or at a jurisdictional level. And if I just give one example, and I'll do this without going to the case, if I may, but simply to highlight the point, and I'm happy to come back on reply on this. My learned friend, in his written case, gives one specific example in relation to the Baltic flame, where the suggestion is that in that case, the alternative was Saudi Arabian law, where in fact there would not have been a right of contribution. And the first point to note is that there was no suggestion, in fact, in that case, that Saudi Arabian law might apply. What was being said was if this case went to a forum within Saudi Arabia, then there would not be a right of contribution. That is quite separate from saying that there was a possibility of Saudi Arabian law applying if the applicable law question had been raised. And, my Lord, I will simply give your Lordships a reference, which is page 508 and 516, paragraphs 8 and 40, that if one does see... Again, please. Sorry, my Lord. My Lord, the page 508 and 516, thank you. And in those pages, paragraph 8 and 40, what one will see from that is that the only laws that appear to be in play in that case was English law under the relevant international transport contract. So, and indeed on both sides of the triangle. And as I said, one gets that from paragraph 8 and paragraph 40. So, my Lord, that's an example of just illustrating the point that one has to look at this a bit more carefully. And the suggestion that the point was being missed, which I understand would be an unlikely one, in fact isn't a good one because, of course, there doesn't appear to be a case there in the first place. The relevant law that was being identified, if any, was English law, certainly not Saudi law. Indeed, the chance of Saudi law applying to the relevant contribution would have seemed to be vanishingly unlikely. And thirdly, that then ties in with, in a way, what we say the key point. My learned friend's point is to say that it's extremely unlikely the point would have been missed if a good one. And the answer is, we agree. The premise to be taken from that is it wasn't a good one in those cases. But what it wouldn't have been, what would be very unlikely, is that the eminent practitioners or judges in those cases would have thought that there wasn't a point to take. And the reason one can say that is because if they'd simply looked up at the relevant time, the relevant section in Dicey and Morris, or if they'd done a bit more research and looked at the relevant Law Commission papers, they would have seen that there was a very clearly arguable line that they should all be subject to the choice of law. So this premise that there was a good point that was missed in my submission just doesn't go anywhere. So, Lords, we do say that the cases that my learned friend relies on go nowhere, both in terms of their actual decision or in terms of any inference that can be drawn from the fact that points weren't taken. The clear inference is there weren't points to be taken in those strikeout or jurisdiction cases. Lord, your Lordships raised with us this morning the Comex Holder decision of the House of Lords. Now, Lords, again, I don't know whether your Lordships have a copy of that.
No, well, my colleagues don't.
Well, Lord, we do have copies, but just to indicate what I was proposing to do, but obviously subject to any directions from your Lordships. We do say this is a very materially different case.
Yes,
and I was going to set out why it doesn't assist.
Yes, I wasn't expecting you to address us on it. It was simply to make sure you were aware of it.
Exactly. But your Lordship's quite right to raise it. And what I was going to do was to set out why we say it's materially different. Of course, if my learned friend takes a different view as to its relevance, having heard what I say, then, of course, I can reply on anything specific. So that's what I was proposing to do in relation to the Comex Holder decision. Now, Lord, the headline points in relation to that decision...
Well, if you are going to address us on it, you'd probably better circulate
yes,
copies.
We've got some hard copies that we printed out this morning, if your Lordships... I'm not going to be taking your Lordship to any specific pages, but obviously I understand your Lordship. It's better for your Lordship to have copies. Thank you.
Thank you.
Thank you. Thank you very much.
Charles. I've got a spare that's fine. Don't worry.
So, the headline points I was going to make were these. This case related to the Scottish Law Reform Miscellaneous Provisions, Scotland Act 1940, which provided for contribution as a matter of Scottish law. It has some similarities with the 1935 Act, but it's also got some quite distinct differences. One can see on the first page of the headnote the Act itself is set out, section 3.1, and one can see there that the form is rather different from the 1935 Act. where in any actions of damages in respect of loss or damage arising from any wrongful acts or negligence acts or omissions, two or more persons are, in pursuance of a verdict of a jury or the judgment of a court, found jointly and severally liable in damages and expenses, they shall be liable inter se to contribute, etc. The key point here is the reference to judgment or verdict of the jury, and it was common ground in the Comics Holder decision that Section 3.1 could only apply, as a result of its wording, to Scottish judgments. And as a result of that, when it came to contribution under 3.2, where it says, where any person has paid any damages or expenses in which he has been found liable in any such action as aforesaid, he shall be entitled to recover from any other person who, if sued, might also be held liable, such contribution, if any, as the court may deem just. It was held that any action as aforesaid must refer back to 3.1, and if 3.1 was limited to Scottish courts, so must be 3.2. And indeed, from a relatively quick scan of the judgment before it reached the House of Lords, it's clear that the Inner House and the Outer House Court of Session had both rejected the comparison with the 1935 Act. And I'll just give your lordships the references to that, if I may. It's pages 94 from the judgment of Lord Mackay, 105 in the middle on the judgment of the Lord President, and page 115 in the judgment of Lord MacDonald. I'm sorry if I've missed some other references to it. And the key point is that the question of anterior choice of law was simply not an issue in this case. The question was the extent to which I think it was Pennsylvania court judgment, which reflected a settlement between the parties, could be said to fall within the scope of the Act. And the conclusion was that, yes, it satisfied the requirements of being held liable, but because of the terms of 3.1 being limited to Scottish courts, which was common ground, and 3.2 referring back to 3.1, it couldn't be any wider. So, my lords, we say that the statute is therefore very different and the question is very different. And indeed that explains why in the passage from the Law Commission working paper on tort and delict, the learned working party took the view that the Scottish provision, and this was obviously before Comics Holder, might well lead to a different conclusion, because one can obviously see the terms of the 1940 Act are quite different from both the 1935 Act, let alone the 1978 Act. And indeed, that's also the point if one looks at how it's treated by Dicey and Morris. It's treated as a comparison to what is the presumed position in England. And in my submission, that's quite right, because the provisions are materially different. So that was all I was proposing to say about Comics Holder, but obviously I'm happy to return to it and reply if my learned friend seeks to draw anything from it. My Lord, I think I also promised to come back to the relevance of Section 2 of the Bill as originally introduced, which dealt with external awards and judgments, and the extent of the relevance of that provision. My Lord, my submissions are, as I indicated they might be, namely that I do say that it doesn't answer the question. I can understand that it raises additional points. Even with the inclusion of Section 2, you would have had to answer the preliminary question of choice of law. But the answer for present purposes is, of course, that it was withdrawn. And the importance is the circumstances in which it was withdrawn. It was withdrawn expressly by the promoter on the basis that it should tie back to the Law Commission's proposals. And that is, in my submission, the relevant question. So it's not a case where one can understand the Act by reference to deletions and additions. This is a case where the positive intention was to pull the Act back to the recommendations of the Law Commission. And in that regard, your Lordships already have my submissions as to the effect of those. So, Lord, finally, just pulling together the various submissions that I've made, we say that there are strong reasons of principle and policy to apply choice of law rules to questions of contribution, just as with any other non-contractual or contractual obligation. And those reasons of principle and policy are founded on the legitimate expectations of parties and doing justice in cases where there is a foreign element. It's the very rationale of private international law and choice of law rules. These reasons of principle, we say, explain why there is indeed a preliminary choice of law question and why there is, as recognised in Cox, a presumption against overriding effect, recognising that there are obviously different categories. There is nothing in the wording of the 1978 Act, its purpose, policy or context, which is capable of displacing the presumption that the question of contribution should be dealt with by the relevant choice of law rules. And that conclusion is reinforced by looking at the legislative history and mischief to which the 1978 Act was aimed. There is not a hint of a suggestion that anyone had in mind the Act having overriding effect such that it should displace otherwise applicable choice of law rules in a context of where that was the assumed position in relation to the 1935 Act. More generally, it's clear that there's no point of principle or policy inherent in the 1978 Act which justifies the relevant choice of law rules being displaced. Lords, unless I can assist further, those are my submissions.
Thank you very much, Mr. Doctor. Yes, Mr. Hollander.
Lordships, please. The issue before you is ultimately a relatively short question of statutory construction, on which it is striking that every single judge who's either decided or looked at the point has reached the same conclusion. What I was going to do, I was going to start off by looking at Cox and then briefly the statutory materials, then look at the case law and then turn to the sections of the statute thereafter. So if we can start with Cox, which I think is page 617 of the electronic bundle. It starts. Now, it is always tempting, I suppose, to treat anything Lord Sumption says as though it were a statute. But actually what he was dealing with was principally something rather different, as your Lordships pointed out this morning, in relation to extraterritorial effect, properly so called. If you could turn to page 631, which is the start of the analysis on this part of the case. And Lord Sumption at paragraph 26 points out that counsel had two arguments. One is the genuine extraterritorial argument, and the second submission was that the principles enacted in the Act represented mandatory rules of English law, applicable irrespective of ordinary rules of PIL. And he says that they raise the same issue. He deals with the second one, which is the one in a sense we're concerned with here at paragraph 35 on page 635, somewhat shortly, by saying it must follow from his reasons from rejecting the extraterritorial application that the second one fails. And if one then goes on to 632 to see the analysis, he starts off, as your lordships pointed out this morning, in paragraph 27, talking about extraterritorial jurisdiction, properly so called, and indeed is talking essentially about what's been referred to as conduct cases. He talks about it being important to understand what is meant when we talk about extraterritorial application in 28. And it's the last bit, in a sense, which is potentially relevant. The second question, just above E, is one of extraterritorial, is one of application properly so called. It's a question posed by the 1995 Act, which had its counterpart in the common law, namely whether the choice of law arrived at in accordance with 11 and 12 is displaced by some mandatory rule of the forum, not a choice of law principle, but turns on the overriding rules of policy of the forum. Now, the reason that he's talking about rules of policy is what I think he's concerned with is the position in the instant case, where you have a statute which gives nothing away to suggest it either has overriding or extraterritorial effect. Because in 29, he says, in the present case, it's common ground the lex causae arrived at on ordinary principles of PIL, it's not English but German law. And then the key sentence, there's nothing in the language of the Fatal Accidents Act to suggest its provisions were intended to apply irrespective of choice of law, derived from ordinary principles of private international law. So he's looking at a case where, as a matter of straight statutory construction, the argument is entirely clear. And where you have that position, and I would emphasize in the next sentence, such an intention would therefore have to be implied. Now you can see where you're looking at a statute where there is nothing in the statute at all which assists as to extraterritoriality or overriding effect, you're going to have to imply it. And not surprisingly, he says that implied extraterritorial effect is possible, and there are a number of examples, but in most, if not all cases, he talks about whether the terms of the legislation cannot effectually be applied or its purpose cannot effectually be achieved unless it has extraterritorial effect. So you could, that's in a sense a necessary consequence perhaps, or the legislation gives effect to a policy so significant in the law of the forum that Parliament must assume to have intended that policy to apply to anyone resorting to an English court regardless of the law that would otherwise apply. So what he's actually doing in my submission in that paragraph is simply looking at the position where the only reason for determining that a statute has either extraterritorial or overriding effect is that form of implication. And that's all in my submission he's dealing with. And it's a much narrower point than is relied upon by my learned friend. And I would suggest the key to it is that word therefore in such an intention would therefore have to be implied. So, Lord, in my submission, ultimately, of course it's right that there is a presumption in terms of overriding effect, but actually, ultimately, your lordships are going to have to construe the statute. And that's really not affected by anything in Cox. So that's the first point I'd make. Now, we turn to the statutory materials. As I think your lordships are probably aware, there was no general right to contribution prior to the 1935 Act. The right was limited to a number of specific rights under somewhat obscure statutes. The 1935 Act, with its wonderful name, was the first statute to provide for a right of contribution in tort. And as we've seen, there was a 1940 statute in Scotland. But there were a number of problems with it. The ones that were canvassed were particularly, first of all, was no right in contract. The second one was the limitation position And I mean, I have a recollection as a law student of reading all about Wimpey and BOAC and Harvey and Odell. Maybe others on their lordships remember the same, just before the 78 Act was passed, where the law was in a complete mess on limitation as a result of those. There was a further problem on settlement in respect of the main action, because if I can refer to claimant D1 and D2 for these purposes, D1 being the person seeking contribution, D1 needed to prove that he would have been liable to the claimant after a settlement, a case called Stoughton, West Yorkshire, which was rather than a reasonable settlement, which also created problems. And those were, in a sense, the two most important changes that were canvassed by the Law Commission. There's quite an interesting summary of the history of this, and I'm not going to refer you to it, but just so you can have the reference. In Professor Mitchell's book at page 1233, at 4.20, he sets out the problems that the 78 Act, in general terms, was there to resolve. As I said, I don't think I need to turn it because those are different problems. Now, the issues relating to the present, as your lordships are aware, were simply not referred to in the Law Commission report, which led to the Act, notwithstanding, rather curiously, that the Law Commission included Professor North and Mr. Justice Cook, Samuel Cook, as the chairman, both of whom you might have thought would have actually had a particular interest in looking at conflict of law issues. But there's not a word of it. And as your lordships saw this morning, when you look at the draft bill prepared by the Law Commission to give effect to their recommendations, we see that all the sections relevant to the present appeal are missing from the draft. Now, there is no reference to what became 1.6, section 1, subsection 6, to section 7, subsection 3, or section 2.3c. We know from Leonard Friend's analysis and his fantastically brave attempt to rely on these points in his favour that these matters came after the Law Commission, so they don't really help us. And he also showed that 7.3 came even later. He referred to the promoter of the bill, Mr. Geoffrey Patty, and his comments in the consideration of the bill as the promoter. We looked him up over the short adjournment. I mean, he did have a law degree. He never practiced as a lawyer. He was in the army. He was then chairman of the parent of Cambridge Analytica, of all things, and then became, I think, a junior minister. So I don't think one can rely upon what he said as being that of the sort of distinguished lawyers that perhaps otherwise have been relevant to this case. So when Lord Scarman, in introducing the bill, said it was to give effect to the recommendations of the Law Commission, I mean, that was true in very general terms, but not in terms that assist the present inquiry, I would suggest. And there were comments, it's true, Leonard Friend referred to them, from two subsequent Law Commission papers subsequent to the 78 Act being passed, but they cite no authority and provide no explanation and have been rather downplayed in those authorities that have referred to it. So I would suggest that you can get absolutely no assistance whatsoever from the Law Commission or the passing of the statute in terms of the conclusions that your lordships need to reach. So the next issue is the case law. Now, what is striking about the case law is that all the judges who have considered section 1.6 over the years have assumed, or where appropriate decided, that the respondents' submissions were correct. And Leonard Friend downplayed these a little bit, and it is perfectly correct that the point wasn't decided or wasn't an issue in most of these cases except the Hashim. And of course, one has to read them with that point in mind. So, of course, I recognise that, but I would like to spend rather more time on them than my learned friend did, because it is interesting to see what some really quite distinguished judges said about these provisions in the context that they were, in a way which certainly, at the very least, assumes the position for which I'm submitting. And the first of those is the Benati at page 456 of the electronic bundle. So, as your lordships are aware, Mr. Justice Hobhouse held, 456 is the start of it, that the 1978 Act did not require the claim being brought to be procedurally enforceable in the English courts. And we see that from 1622 of the report, which is 464 of the bundle. Just starting perhaps, Mr. Justice Hobhouse and counsel Mrs. Flo and Sybury, he starts dealing with the 78 Act at page 462, and then the relevant bit, bottom of 463, start of 464. He says at the bottom of 463, just right at the end, at the bottom of the page, I consider the Charterer's submissions are mistaken. Section 1.6 is concerned with providing a definition of or guidance about what liabilities may be taken into account for the purpose of Section 1. I consider the section is concerned with the character of the liability and not with any merely procedural considerations as to how it might be enforced. And he refers to Sir John Donaldson in a non-conflict of laws issue. And then the next paragraph, I don't consider Section 1.6 is concerned with such problems as to whether or not a writ could have been served out of the jurisdiction of the court. Such considerations are alien to the substantive scheme that's being provided for in the 78 Act, would serve no purpose relevant to the scheme of the Act, which I am able to discern. If the respondent to the contribution claim is, as of here, a foreigner, then before such a foreigner can be made the subject of a contribution claim, the claimant must establish some procedural right recognisable under Order 11 or other relevant provision which entitled him, the claimant, to proceed against the respondent in this country. If he can't establish that procedural entitlement, no question of liability under the 78 will arise. It can't be brought here. If he can, there is no need for any further inquiry, and the provisions of the Act should be applied. I haven't lost sight of the fact that 1.6 deals not with the liability of the respondent to the contribution claimant, but with the liability of either or both of them to the person who suffered the damage. If the respondent is present within the jurisdiction, his liability could be established here. If the claimant wasn't, what purpose is served by asking purely hypothetically whether he would, if sued in this country, have chosen to submit to the jurisdiction or could have been compelled to do so. So he is assuming, I would suggest, the construction of the Act for which I'm submitting, but there is then the further point, which we'll see when we come to look at Mr. Justice Chadwick and AMF and Hashim, which is this case has got absolutely nothing to do with English law, and therefore it must have followed that if this was a good point, if Millen and Friends' point was a good one, not only did that great lawyer, Mr. Justice Hobhouse, not spot it or not refer to it, but also it would have been an answer to the point in the case, and the counsel had inexplicably missed the point. So that's the Benati. The next one is the Capitan Georgius, which is 466 in your Lordship's bundle, which is Mr. Justice Hurst. There was a separate point here about a direct duty of care, which is irrelevant to the present, but otherwise, Mr. Justice Hurst followed Mr. Justice Hobhouse and plainly had the same view. If you look at 471, the submission made by Mr. Glennie, who had uncovered the Comex case, as you can see from the middle of the right-hand column. And he relied upon the Comex case, when Mr. Justice Hurst refers to that, and when the House of Lords held that on the construction of the relevant provisions of the 1940 Scottish Act, Parliament had in contemplation contributions only in respect of sums recovered in actions in Scotland, and didn't have in any view an international dimension, so that liabilities incurred in Pennsylvania didn't fall within the ambit of the Act. This, he suggested, showed that in this contribution field no international dimension was contemplated. And then Mr. Justice Hurst said, in my judgment, Mr. Jacobs is right in his basic contention, which Mr. Glennie challenges, that the 78 Act creates a cause of action in its own right, the ambit of which is to be discerned from the terms of the Act itself. There's nothing in the Act to limit its scope to liabilities incurred in England and Wales. On the contrary, 1.6, with its references to private international law, is a small pointer in favour of an international dimension. The Scottish case turns essentially on the precise wording of the 1940 statute, which by and large is a counterpart of the 1935 Act, was a bit different, which was the precursor of the 78 Act. And it doesn't regard that as significant. And if you then go to page, he essentially followed and cited in detail on page 472, Mr. Justice Hobhouse in the Bernati. And if you just look at the top of page 473, please, in the first paragraph, just right from the beginning, I'm quite unpersuaded that the form of section 1.6, and in particular, and particularly its opening phrases, points towards Mr. Glennie's construction. It seems to me there were very solid grounds for the draftsman to formulate section 1.6 in this manner, to make it clear the law of England and Wales is the main criteria. Subject to the important rider, this includes the applications of the rules of private international law by reference to foreign law. This important provision, going beyond anything in the 1935 Act, is well worthy of the careful exposition it receives in the subsection. So, again, the same point could be made as was in respect to the Bernati, that not merely is it apparent from those comments, although Mr. Justice Hurst wasn't focusing on our point, that he thought it applied to cases in English courts, and, of course, if I'm wrong, then this is a point which counsel in that case also missed. The next one is the one decision, as your lordships know, where the court actually decided this point, which is Mr. Justice Chadwick in Arab Monetary Fund in Hashim, which is 476. And I think one starts off by looking at the submission, which is a submission made in the present case, at the bottom of 478. Mr. Ross Monroe, on behalf of Dr. Hashim, submits that this view of the Act is oversimplistic and incorrect. He submits the 78 Act does not apply to all contribution claims brought in the English court, but only to those claims governed in accordance with the rules of private international law applicable in that court by English domestic law. If this submission were well-founded, there would be a preliminary question in contribution proceedings involving foreign elements. Is the contribution claim which B makes against C governed by English law? That's the starting point. He then goes on 479 to deal with the Law Commission working papers, and he refers to under the heading Law Commission working papers, the submission placed on the papers that were referred to by my learned friend, and just after the citations, if your lordships have no authority is cited. No authority is cited in the working paper for the proposition the 78 Act will apply only to claims for contribution, where the law governing the claim is English law. The view expressed in paragraph 76 of the paper 75 was not reflected in the subsequent Law Commission report. The relationship between contribution and limitation is discussed briefly. The Law Commission accepted that amendment of the 78 Act was neither necessary or desirable, made no proposal relating specifically to the law of contribution between joint wrongdoers. The view expressed in paper 75 was carried forward to a subsequent working paper on a different topic, and then refers to it. And again, at the bottom of the page, Mr. Justice Chadwick says that no authority was cited for that proposition. So he rather puts aside those matters. If we then go on to page 481, please. The bottom of 480. He's describing the paragraph at the bottom of 480 in deciding whether. He's describing what he refers to as the geometric model, as the proper construction of the 78 Act. About 6 lines into that paragraph, the English court is concerned, if your lordships have that, the English court is concerned with what, to borrow the geometric model described, may be referred to as the other two sides of the triangle. If those two sides are established, in the sense that both B and C were or would be liable to A in respect to the same damage, then the third side is put in place by the statute in deciding whether the other two sides of the triangle are established. The questions which the court has to address in contributions brought under the 78 Act are those I've identified previously. And then in the next paragraph, it would be strange, therefore, and this is a point I do reflect upon, if before it came to construe the 78 Act at all, the court were required to answer a preliminary question which was unrelated to and inconsistent with the basis upon which the statutory right of contribution arises under English law. To ask whether a right of contribution arising out of any relationship between B and C other than their relationship as persons, each of whom is liable to A, in respect of the same damage, or to be determined by English domestic law, would be to ignore the basis on which the right arises under that law. To ask whether a right of contribution arising out of the relationship between B and C as persons each liable to A in respect of the same damage would be to ask the very question to which the 78 Act provides the answer. And then he makes the point, he deals with the Benati and the Captain Georges, and if you can look towards the bottom of page 481, the paragraph starting the owners of the Benati, penultimate paragraph on the page, and he deals with the facts. The bills of lading included an exclusive Indonesian law and jurisdiction clause, vessel on passage from northern Europe to Indonesia. Cargo damage occurred in the Bay of Biscay. If the court had thought it necessary to address as a preliminary question what law ought to govern the shipowner's claim for contribution against the charterers, it's difficult to see how that question could have been answered in favour of English law on any ground other than that cargo owners' action against the shipowners were proceeding in the English court, the shipowners having submitted the jurisdiction. Mr. Justice Hobhouse didn't address that question. He dealt with the matter on the basis it raised a question of construction under the 78 Act. A similar point on the next page, 482, in relation to the Captain Georges, third paragraph of the page. The charterers of the Captain Georges were a company incorporated in the United States. The shippers were a Canadian federal-owned company. The damage was suffered on a voyage from Cape Breton Island to Hamburg. The cargo was shipped pursuant to a contract containing a Canadian statutory clause, placing liability in respect of explosive cargo on the shipper. The only connection with England was that the shipowners had chosen to bring the action against the charterers in London. Again, if Mr. Justice Hurst had thought it necessary to address the preliminary question what law ought to govern the charterers' claim against the shippers, it's difficult to see how that question could have been answered in favour of English law. Like Mr. Justice Hobhouse in the Benati, Mr. Justice Hurst didn't address that question and dealt with the matter on the basis the solution to the questions before him was to be found in the 78 Act. And then if I can just, last passage I want to take your lordships to is on page 483. Second paragraph of the page. It doesn't follow the 78 Act is capable of being applied indiscriminately whenever two parties are liable for the same damage under foreign law. The criteria under 1.6 is that the liability has been or could be established in an action brought in the English court by the person who suffered the damage. Although it's immaterial that in deciding whether or not liability is established, the court may, in accordance with its own rules of private international law, apply foreign law. The liability is a liability which could be established in an English court. So, for example, liability under foreign law alone in respect of a tortious act committed abroad would not be sufficient liability under English law. It would also need to be established in accordance with double actionability in boys and chaplains. So, of course, when the Act was passed in 1978, there was a double actionability requirement, which subsequently disappeared. And therefore, when one comes to C in Section 1.6, when one talks about an action in the English courts, which could be brought in English courts, one is recognising the need to satisfy double actionability criteria. And then, finally, on this case, it follows that if the English court assumed jurisdiction in the litigation in which Professor Glanville-Williams and Ruritanians were involved, and after applying Ruritanian law in accordance with Boys and Chaplain, reached the conclusion that two were liable to the third in respect to the same damage, it would, in my view, not only be conceivable but correct in law for the court to apportion the damages between B and C and to say. It would be remarkable if the court couldn't do so. It would be a surprising defect in the law if the English court, having decided in an action to which A, B and C were party, that B and C were each liable to A in respect to the same damage, suffered in, say, a collision between motor vehicles in Ruritania in which the three were involved, and having assessed that damage, were precluded by the absence of any law of contribution in Ruritania from deciding also how its judgment for that sum against each of them should be apportioned into say. And he's satisfied it's not a feature of English law. And then we move on to the last of these cases. Which
Just
is
before you leave that, leave that one, Mr. Hollander, could you look at the passage which begins, "It does not follow"? I think it's probably 483 in your notice.
Yes, it is.
Okay, well, it's the last bit. As he points out, liability under foreign law alone in respect of a tortious act committed abroad wouldn't be sufficient because of the then rule of double actionability.
Yep.
And then this. But if that test, i.e. double actionability, is satisfied, then it's immaterial whether a right of contribution between the tortfeasors exists under foreign law. So the question which exercises us in this case could never arise, could it?
Well, isn't he simply referring to the... If there's double actionability, but so you're looking at three different relationships.
Yes.
Relationship one is claimant versus D1.
Yep.
Look at claimant versus D2, and you're also looking at the relationship between D1 and D2 for this purpose. Isn't double actionability is surely relevant for the purpose of the first two of those?
Yes.
But not the third?
Well, why does he seems to think that it must follow that if you've got double actionability, you've also got English law applying to the contribution.
But I had read that as saying that under proper construction of 1.6,
yep,
once you've got double actionability satisfied on the stages 1 and 2, there's no further inquiry about proper law. I think that's what he said.
Yes, I follow. All right, thank you very much.
The last of these cases is the Baltic Flame, which is after Hashim, and it's page 506, where it's a decision of the Court of Appeal. So this was an attempt to set aside this. It's slightly complicated on the facts, and I need to show you just a little bit, because I don't think, with respect, my learned friend is right. I would say, and I would say the same point arises, that these rights would be, it's between Fortum and Saudi Aramco that the right of contribution arises. And I don't, as I read it, and I've just been looking at it because my learned friend mentioned it just after the shortage, I don't think there is any relationship between Fortum and Saudi Aramco. Fortum are the time charterers, and Saudi Aramco are the shippers. And I don't think there's any relationship between them. Because when my learned friend says, but the relationships are all English law, that would only arise if there was some arbitration clause of some sort, because I don't think there's any suggestion that proper law otherwise would be English law. And I think the relationships are between Mellitus, and it's slightly complicated. Let's just look at paragraphs 8 and 9, if we may, on page 508. At 8, the bill of lading contracts pursuant to which Mellitus claimed damages against Saudi Aramco, expressly incorporated the terms of charter parties, including the arbitration clause. The relevant charter parties were in the Aspertankvoy form, additional clause 33, of which provided for LMAA arbitration in London, contract being governed by English law. So that's between Mellitus and Saudi Aramco, and there's a London arbitration clause. And then if you look at 9, at a case management conference, Fortum obtained permission to serve its own Part 20 claim forms in both actions upon Saudi Aramco out of the jurisdiction. The order was made on the basis that Saudi Aramco was a necessary and proper party to the proceedings under 11.1c, because to the extent that Fortum is liable to Mellitus under its time charter, then so too must Saudi Aramco be liable to Mellitus under the bills of lading. That's relationships 1 and 2, thus entitling Fortum to claim a contribution from Saudi Aramco under Section 1 of the 78 Act. So I don't think there's any relationship between those parties other than the right to contribution. At the time of the order for leave was made, the attention of the court was specifically drawn to the fact that the Part 20 proceedings commenced by Mellitus against Saudi Aramco had been made subject to a stay on the ground that that claim was subject to arbitration. So I think it's freestanding. Now, just to complicate the matter, before I come to the point that I want this case, is just to respond to my learned friend's point. There, in paragraph 34 of Lord Justice Potter, there is what I think is an error. If you look at 515, and if you have, well, I'll come back to this in a moment, different context, but if you have just halfway into the left-hand column in paragraph 34, it's just after reference to the law of a country outside England and Wales. In that context, I don't know if your lordships have that. In that context, the use of the words could be connotes that a substantial or remedial criteria of liability is being referred to, and that the subsection is concerned with the character of the liability and not merely procedural considerations, see the Benati. Thus, the mere fact the claim of Fortum against Saudi Aramco is subject to a stay for the purpose of arbitration is no bar to Fortum's contribution claim, which is itself subject to no requirement of arbitration and indeed is unenforceable unless it's permitted to be pursued. I think he's got that wrong with respect. I think what he's talking about is the claim of Mellitus against Saudi Aramco. I don't think it makes sense otherwise. Anyway, I'll be corrected if anyone thinks I've got that wrong, but I just don't think it makes sense. I think and I don't think there is any question. I think the claim between Fortum and Saudi Aramco is a pure statutory claim for contribution, and there's no arbitration, in which case English law would have nothing to do with it at all, because none of these events took place in England, or the only relevance of English law is because of the English law clause in the relevant contractual documentation. So but that's just the point that a friend was making. If we then go to what Lord Justice Potter says, to which the other members of the court agreed, which starts at 31 on page 514, I now turn to the submissions of Mr. Gazeman. He's the one, I think, who's missed the point, as well as Mr. Justice Longmore and all three members of the Court of Appeal, if my learned friend is right. I must say I was experienced with Mr. Gazeman, as he doesn't often miss points, but there we are, who knows. I turn now to the submissions of Mr. Gazeman as the special factor central to the judge's decision, namely that unless Fortum could maintain its contribution claim against Saudi Aramco in this country, it could not be enforced or otherwise provided for because the law of Saudi Arabia allows no remedy of contribution. And then at 34, on page 6515, as made clear by Mr. Justice Hobhouse in the Benati, for the purposes of recovering contribution under Section 1 of the 78 Act, the liability to the injured party of the person from whom contribution is sought does not need to be procedurally enforceable as a current and subsisting liability, provided it had the character of a liability at the time the damage was inflicted or suffered. All that is required is that liability has been or could be established in the action against him in England and Wales by or on behalf of the person who suffered damage. See section 1.6, which also provides, and then there's a reference to the words of the Act. In that context, you've seen that point that I've read. And then in 36, on the right-hand column, nor in my view is it. The 78 Act is strictly territorial in scope. However, it is unequivocal in its application to all proceedings brought in England, and there is nothing in the Act, or in particular in section 1.6, to limit the right of contribution to liabilities incurred in England and Wales. See the Captain Georges. Contribution proceedings are in turn generally proceedings appropriate to be tried in the course of proceedings already afoot. The draftsman of the 78 Act and the Rules Committee may be taken to have had in mind the combined effect of the 78 Act and 1111C would be to permit joinder of a foreign party who would not be liable if sued directly in his own country. Similar issues arise in cases where the limitation period in the foreign country may be different from that in England. So, no prizes for guessing what Lord Justice Potter thought the proper construction of this was. Before I leave the case law, can I just mention briefly an authority that my learned friend referred to in his case, but didn't refer to orally, for reasons I'm about to show you, I suspect. This is the Fluor case, which he deals with, just so you have the reference, paragraph 104 of his case, on page 60 of your bundle. And this is a case he relied upon at first instance before Mr. Justice Sewell. He did not rely upon it in the Court of Appeal, and he hasn't referred to it orally, but let me just briefly deal with it if I may. It's at page 591 of your bundle. It is quite interesting, but doesn't, my submission, help you. And at 609, this is the Victorian Wrongs Act 1958. At 609, the relevant bit of this case starts at paragraph 39. Now, section 23B of the Wrongs Act, the Victorian Wrongs Act, is worded in precisely the same way as the 78 Act. And that's why it could be thought to be relevant. Unlike every other Australian statute, state statute, it provides for contribution in Victoria in contract as well as tort. So what Fluor sought to do was to sue in contribution in Victoria, although Victoria had nothing whatsoever to do with the case, and therefore argued that Victorian law applied to the contribution claim. And you can see that. It refers to, paragraph 39 refers to the statute, and then this is Mr. Justice Bongiorno. And in 39, section 23A, page 609, provides that contribution between wrongdoers is available, whatever the basis of each of their liabilities, to the person who suffered damage might be, tort, breach of contract, trust, or otherwise. In this respect, the statute follows the form of a UK statute, that's ours, which in Australia is unique to Victoria. Contribution statutes in other Australian jurisdictions confine rights to contribution between tortfeasors. And then we go to the next page, 610. ACSC, paragraph 41, argues that any contribution claim brought by Fluor must be determined by application of the law of Western Australia, namely the 47 Act and not the Wrongs Act. If this argument succeeds, it would lead to a determination that Fluor's claim was incompetent for the reasons already referred to. ASCE contends there's no nexus between the facts giving rise to the claim and the state of Victoria. The contract on which Fluor is liable to the joint venture contains a choice of law clause nominating Western Australia as the law by which the contract was to be governed, and almost all the facts relating to the case occurred in that state. Those that did not occur in Western Australia occurred in South Australia, none in Victoria. And then at 44, Floor contends that common law, there's no settled choice of law rule governing claims for contribution, but in any event, the choice of law question is answered with respect to the claim in the Victorian court by Section 23B of the Wrongs Act. This section enacts a statutory choice of law by prescribing the Victorian law will always be applied, so that's the same argument in principle as here, to a claim for contribution brought in the Victorian court. That's so whatever law the court may have to determine questions concerning the underlying liability of the parties upon which the claim for contribution is based. So that's the argument, and refers, you can see on page 612, the judge refers to the Benati and the Captain Georges and AMF and Hashim. But the decision starts at relevant at paragraph 50 on 613. None of the cases relied on by Floor considered the question as to whether the UK statute could ever be displaced by a foreign statute concerned with the question of contribution between wrongdoers liable for the same damage. I would have thought that's what AMF does deal with, but there it is. That's to say, none of them address the issue as to whether there's a logically anterior choice of law question to be determined. Well, isn't that what Hashim did determine? But the unqualified application of the principles expounded by these English cases in the context of the Australian legal system would mean that any Australian state or territory could legislate to provide remedies available to any litigant who sued in the courts of the legislating polity, regardless of whether the factual circumstances of the case or other governing factors had any geographical or other connection with the territory of that polity. Fleur's argument means that that's what the Victorian Parliament has done by enacting Section 23B. If its argument is correct, all a claimant for contribution has to do is to resort to a Victorian court to obtain the benefit of considerably wider rights to contribution available under Victorian law than those available elsewhere, including in the jurisdiction in which all the factual elements of the cause of action of contribution may have occurred, and even in circumstances where the parties had themselves stipulated the law they wish to govern the rights inter se. No connection with Victoria need to be established. And then he goes to say this is contrary to the Australian Constitution. Fleur's argument ignores the High Court decision in FIFA, where the majority judge made it clear that choice of law rules for Australia are provided by the common law adapted to the Australian Constitution. Their honours considered that these rules should provide certainty and uniformity of outcome, no matter where in Australian Federation a matter is litigated and whether it's litigated in federal or non-federal jurisdiction. Although FIFA was concerned with tort liability, its principle is wide enough to encompass liability and contribution, as that right is understood in the statutes of the various Australian jurisdictions. It couldn't be suggested that contribution concerns only procedural rights so as to give primacy to the law of the forum. The principle in FIFA is as much applicable to such a claim as to a claim in tort. This is so whether a claim to contribution can be characterised as restitutionary or defined by reference to the character of the underlying liabilities on which it's based and can be described in some other way. The acceptance of Fleur's argument would mean that a remedy provided by the statute law of any state or territory in Australia would be available to any litigant in respect of any fact, situation to which the remedy could be applied wherever it occurred by a simple process of commencing a proceeding in the jurisdiction. And then 54, consistently with FIFA, the unique Victorian remedy of contribution should be available to and in respect of wrongdoers, regardless of the juridical source of their wrongdoing, only in those cases to which, by the application of appropriate common law choice of law rules, Victorian law should be applied. So essentially, this is decided on the basis of the Australian Constitution. So those are the authorities. I can just deal briefly with the academic texts. All I really wanted to say about them is it's perfectly true that there's some academic materials which support the learned friend. None of them, in my submission, look at the statute and the sections with the detail that all the judges in this case have done and have had to do, and much of it has very limited reasoning. And if I may say so, particularly in the absence of Lord Burrows, academic views often focus less on the statutory construction and more on the question of principle, and sometimes run together what the law is under a statute with what they think the law should be. Anyway, matter for your lordships in respect to that. The other point to make about this is that if there is some academic support on one side, it is very striking that every single judge who's considered or determined this has taken the alternative view. So I'm now going to move on to the statute itself, running rather ahead of time, I must say, so far. This is in page 252 of Your Lordship's electronic bundle. And
which actually, can I just interject? It just occurs to me to express our appreciation of the fact that we had succinct written cases in this appeal. I'm afraid so often we've set a maximum of 50 pages, and that seems to have been treated very widely as a target. And it's a great advantage to us to have a written case that's no longer than it needs to be. And that was achieved by counsel in this case, for which we're grateful.
Well, in Hong Kong, where I also practice, the Court of Appeal there has a page limit of 15 pages for all skeletons. And I usually spend more time on trying to get my skeletons under 15 pages than on the substance of the skeleton. But so we're going to 252, if I may. Which is the statute itself, and at 254, so the threshold. And I mean, the point is an important one in my submission, that one has, according to my learned friend, to read this as being subject to something which says, before this act only applies in circumstances where the proper law of the right to contribution is English law. And that is, I mean, it's logically possible, but that is, and that's the point made by Mr. Justice Chadwick, but that is what he has got to say, notwithstanding the fact that the Act purports to set out comprehensively the circumstances in which, in the English courts, contribution is determined. And the combination of 1.1 and 1.6 provides for a threshold, if you like, as to when the Act applies. And the learned friend's submission is, well, you don't get to the Act at all unless English law applies to the right of contribution. But of course, you have to look at the Act to determine whether that's right. And you've got to look at its terms to see whether it would apply in that situation. Now, so on the face of it, 1.1 and 1.6 provide that those are the threshold conditions before a statutory right of contribution, which provides a statutory cause of action, has effect in this jurisdiction. And of course, subject to the following provisions, which in particular for present purposes will include 1.6. Any person liable, which is D1, in respect of any damage suffered by another person, the claimant, may recover contribution from any other person, D2, liable in respect of the same damage. So on the face of it, it is difficult to see, I would suggest, that is subject to this prior question that the learned friend raises. I pass on to look at 1.3 very briefly, and this is only a small point. But the wording of the end of, so this is about, 1.2 and 1.3 are both about limitation and sorting out the Wimpy and BOAC issue. 1.2 is about the first defendant's position, and 1.3 is about the second defendant's. D2 will be liable to make contribution, notwithstanding that he ceased to be liable, that's the limitation point, unless he ceased to be liable by virtue of the expiry of a period of limitation or prescription, which extinguished the right on which the claim against him in respect to the damage was based. Now, again, this is only a small point, and it's not an important point in the scheme of things, but that wording, particularly at the time, was common in looking at foreign law statutes of limitation and the difference between extinguishing the right and the remedy. And therefore, it is at least a further indication of sorts that the draftsman had in mind foreign law. Now, I think Lord Justice David Richards said, well, but there are English statutes which have that same effect, and I think there are not many of them. I think maybe the Moneylenders Act is one, but there are not many of them, but that is at least some small indication.
But we know that the draftsman had foreign law in mind, don't we, from 1.6?
Exactly. That's why it's only a small point.
Yep.
So back to 1.6, after 1.4 settlement and 1.5 is UK judgments. References in this section to a person's liability, that's of D1 and D2, and that it defines what is set out in 1.1 in respect of any damage, are references to any such liability which has been or could be established in an action brought against him in England and Wales, and that's what brings into effect the double actionability. By or on behalf of the person who suffered the damage. But it's immaterial whether any issue was or would be determined in accordance with private international law by reference to foreign law. So I've expressly takes into account the private international law. If we can just see now what the judges below said about that section, it's perhaps just worth looking at that. 137, please, in the bundle. First of all, Mr. Justice Sewell. Page 137, paragraph 92 of his judgment. He says it's implicit from the provisions of the 78 Act, the statute does have overriding effect, the presumptions rebutted. Consider the express references in the 78 Act to PIL 16 and 23C support this implication, Parliament having chosen to identify specific circumstances in which choice of law rules are to apply, and the extent of that application. In a claim under the statute, the natural implication is that the availability of the statutory cause of action wasn't itself to be subject to choice of law rules. And then 96, bottom of the page, on its proper construction, Section 7.3 is consistent with this conclusion. We'll come to that in due course. In the context of the express references in Section 1.6 and Section 2.3c to private international law, I consider the natural meaning of supersedes any right is that any right includes any right of contribution which would otherwise arise under foreign law. See also Hashim, don't accept the exception in 7.3 for contractual provision which excludes a contribution claim is appointed the other way. We'll come back to 7.3 otherwise. And 97, further pointer is provided by the combined effect of Section 1.3 and 6, where the statute makes express provision in a case where the Act applies to disregard foreign law limitation which bars the remedy, it'd be inherently anomalous to provide otherwise for the purpose of deciding whether the Act does apply. The implication must be this was not the statutory intention. And 101, as to the academic articles, their principal source of doubt is drawn from the comparison with the 45 Act, and then in tentative terms. For the reasons already given, I respectfully consider there's a real distinction between the two statutes. Unlike the 45 Act, the 78 Act does make express provision for private international law. This includes express provision for the application of foreign law, which has corresponding limits or reductions to those in the 45 Act. See Section 2.3c. If we then move on to Lord Justice Irwin, page 100, at paragraph 54, having set out principles of statutory construction, he turns at page 100 to the 78 Act. Entitlement to the contribution claim, provided one was dependent on 1.2, 1.3 and 1.6. The incident case is a tort claim. We'll illustrate the provisions talking about claimant tort visa 1 and tort visa 2. Beginning with 1.6, the liability of tort visa 1 and 2 to the claimant is confined to liability which has been, you've got the wording, this threshold condition arises in respect of each of 1 and 2. In my view, the second part of 1.6, in making the qualification which follows, it's immaterial whether any issue and so forth, makes two things clear as a matter of ordinary language. Firstly, the relevant liability must have been or must be able to be established in an English court, but not necessarily by application of English law. For example, in a case where the application of PIL has or would result in a ruling that an English court will be the forum conveniens, then the threshold condition will be satisfied, even though the English court would apply foreign substantive law. It seems to me the phrase any issue can't be read down to mean any single issue. On the face of it, therefore, the necessary threshold condition could be established where an English court gave or would give judgment against 1 and 2, even when applying foreign law to all the issues of the case. Mr. Doherty's argument is this question doesn't even arise, since by operation of first principles, the Act cannot apply where by operation of PIL the proper law of a contribution claim is foreign law. Seems to me a problematic argument. If I'm right about the natural meaning of the language in 1.6, it's not a straightforward question of the Act providing a complete code. The question is crisper. Provided liability can be established against tortfeasor 1 and 2, so as to gain judgment in English court whether or not any issue or issues are decided by foreign law, the threshold condition for a contribution claim is fulfilled. If by its own terms the Act applies in relation to the principal liability of the tortfeasors, even where the proper law of the tort is foreign law, then why should a consequential contribution claim, where the proper law of the claim is foreign law, fall outside the ambit of the Act? And then at 64, on page 102, looking at the provisions themselves, it seems to me the purpose of Parliament is totally clear. At the forefront was the object of simplifying and standardising contribution claims, whatever form of liability gave rise to the common liabilities of the person suffering damage. This was the main thrust of the interpretation of liability and damage set out in 6.1. As the clear purpose for change in domestic law, this was well articulated by the Law Commission in paragraph 73 and 74 of the working paper. As Professor Briggs accepted in his 95 article, there is an immediate attraction to that result. Parliament then had in contemplation the two important criteria by which the liability of those in respect of whom contribution might arise to be established. 1.6, stipulating that liability must be capable of established in England, also stipulated that it might be established on the basis of foreign law. If so established in a given action, there was an obvious question as to what law would govern contribution claims in such cases. The Act is wholly directed to contribution claims. It would have been simplicity itself to provide that where the proper law of the contribution claim was a foreign law, the statutory right didn't arise. It set no such limit or exclusion. And then he goes on to 7.3, much narrower limits were set. In my judgment, the natural interpretation of the language of the Act sits well alongside a presumed purpose of a standardisation and simplification of limits on the statutory claim for contribution, which otherwise would be affected by foreign law. As Justice Chadwick identified in Hashim, there would otherwise arise a lacuna or defect that principal liability could be established in English court against tortfeasor 2, including established a principal liability according to foreign law, but a contribution claim could be defeated. Whilst I accept Mr. Doherty's comment there's no inherent defect in German law, it's logical in a standardising and simplifying statute that such consideration should be set aside once it's shown that primary liability can be established, if necessary, by reference to the relevant foreign law. And then Lord Justice Phillips' rather brief judgment at 74 on page 104. He agrees with both the other Lord Justices at 74 that it's plainly implicit the statutory right of contribution under 1.1 arises regardless of the law which might otherwise have governed such rights between the parties. In my judgment, such implication arises not only because of the interplay between 1.1 and 1.6, but also because the rights of contribution superseded by virtue 7.3 must be taken in the context of provisions which fully recognise the likely relevance of private international law to include rights of contribution under the otherwise applicable foreign law, the creation of a statutory right of contribution as between persons, notwithstanding the liability of one or more of them arises under foreign law, and the exclusion of other rights, that's the 7.3 point, save for express contractual rights, can and should be read together as giving rise to the plain implication that it has extraterritorial effect. And then Lord Justice David Richards at 89, he took a different view on 7.3, which we'll come to in a moment. But if you look at paragraph 89 on page 108, so he refers to paragraph 89, section 1.6. First part of that subsection provides it's sufficient for a contribution that the liability of each of them to A has been or could be established in an action brought against them in England and Wales. He then refers to the Baltic Flame. He says that it's not about procedural. It's not about procedure. It's directed at substantive law. What's postulated is liability that is or could be established in English proceedings. And then at 92, importantly, the effect of 1.6, in my judgment, is a contribution claim lies under the 78 Act and is thus governed by English law, even though the liabilities to which it relates, that's the liabilities of B and C to A, may both be governed by foreign law, expressly contemplates the situation in the present case where any liability of SSAFA and AKV to the claimant will be governed by German law, but a claim for contribution will nonetheless lie under the 78 Act. It might be said this will be so only if the contribution claim would, under private international law principles, be governed by English law. The chances of a contribution claim in such circumstances being governed by English law appear to be small to the point of invisibility. Just pausing there a moment. The learned friend's efforts to try and find examples where David Richards may be wrong, I mean, whilst I can see that there might be examples one could dream up, suggests that it's not straightforward to find such examples at all, and that there's a lot of force in what he says in the last sentence of 91. The conclusion is that inescapable, he says in 92. So that's section 1.6. Section 2.3c is less significant than 1.6 or 7.3, and it's back to the statute itself at page 256. 255 section 2.3 is looking at where the amount of the damages would have been subject to limits, either from enactment under A, contribution negligence B, or C is the important one, any corresponding limit or reduction under the law of a country outside England and Wales, then it should not be, by virtue of any contribution awarded under Section 1, be required to pay, in respect of the damage, a greater amount than the amount of them so limited. I think that is, again, looking at the position on a foreign statute, and taking into account a limitation under a foreign statute which may limit the amount of contribution which would be payable. That's 2.3c, and the other one is 7.3 on page 258. And here we have the point where the majority of the Court of Appeal took a different view to Lord Justice David Richards. 7.3 on 258 is that the right to recover contributions supersedes any right. Now, this is a careful section with respect, where it actually identifies exactly what it is superseded and what is not. So it lists all those things that are not superseded, the express contractual right, but the express contractual right is subject to an indemnity under 3A. In other words, that doesn't affect that, and any express contractual provision regulating or excluding contribution. So it's quite a careful section. It supersedes any right. Now, the majority of the Court of Appeal thought it was significant, and as did Mr. Justice Sewell, Lord Justice David Richards thought it wasn't. In my submission, Lord Justice David Richards rather sold 7.3 short. But on its natural construction, this must exclude a right of contribution under foreign law. That's what it says, any right. It's not limited, and when it doesn't mean any right, it makes it clear in the rest of 7.3 what it doesn't cover. Now, so one has to look at the statute to decide whether my learned friend is right or I'm right, because you can't determine that other than by looking at the statute. 7.3, on its face, provides that any other right, other than those covered in the rest of the subparagraph, is excluded. And on its natural construction, in my submission, that must include a foreign law right. Now, Lord Justice David Richards said, well, essentially, you can argue it both ways. If Mr. Doherty's right, it is neutral, and if Mr. Holland is right, it helps him, as it were. But that really isn't good enough with respect, where you have those words, because what it means is that when the learned friend says that you have to read those words restrictively in a way that is inconsistent with the natural meaning. If you look at, let's go back to Lord Justice Irwin, page 102, please. Paragraph 60. If 102, Mr. Holland is correct, the phrase any right under 7.3 includes a right under foreign law. Sorry, I'm ahead of you. Page 102, back to the Court of Appeal, Lord Justice Irwin at paragraph 60. If Mr. Holland is correct, the phrase any right under 7.3 includes a right under foreign law, seems to me that's a powerful argument in his favour. Supersession by the statutory right to contribution under the first part of the subsection must be read alongside the limits of the supersession by the statutory right in the second part. Setting aside questions of indemnity, the supersession by the statutory right is not affected by a provision regulating or excluding contribution other than one which is expressly contractual. I find it hard to see why this shouldn't be thought to include foreign law. We were given no examples of an English provision other than a contract which might have this effect, but of more importance may be the terms of 1.6, which we've already seen, the liability of both tortfeasors to the claimant, provided this is established in England, may be determined by foreign law. Given that is so, it seems to me that it would be surprising and not a natural use of language if Parliament is not taken to have had in contemplation that foreign law provisions affecting indemnity might arise. If that was contemplated by Parliament, the natural reading of 7.3 is that such provisions fall outside the exclusions and with the supersession provided by 7.3. And I think I've shown you already, Lord Justice Phillips, but perhaps just focus it again, page 104, in this particular context.
Well, what about 60?
60?
Yeah, I think it was 60. We weren't given any examples of any rights that might arise other than... Is that paragraph 60?
61, I think.
Beg your pardon, 61. We were given no examples of English provision other than a contract which might have that effect. Well, I've no idea how it was argued there, but here, is it or is it not agreed that there are actually quite a lot of relationships which give rise to rights of contribution?
Well, I think I think possibly that's going further than is correct, in that I think there are others. Which is why I think my point is really that the natural wording of this...
Common sureties, common guarantors, trustees, directors.
The bit that a friend referred to, where he puts it too high, is in 1230... Sorry to take it out of court.
No, that's all right.
If you look at 1236 of the bundle... So I think there are others. This is in Professor Mitchell's book.
Yeah.
At 4.25 on page 1236.
Sorry, reference again, please.
I'm so sorry, 1236.
Thank you.
This is Professor Mitchell's book on the 78 Act at 4.25. And this is the passage my learned friend relies upon in respect of 7.3. So he says at 4, Professor Mitchell's 2003 book, the court's jurisdiction under the 78 Act is exclusive. 7.3 provides the right to recover contribution under the Act supersedes any, etc., etc. Hence, for example, the entitlements of a trustee liable for breach of trust to recover contribution from his fellow trustees, and of a director liable for breach of fiduciary duty to recover contribution from his fellow directors, both of which were well established in equity prior to the passing of the 78 Act, now clearly fall within the scope of the Act. So, I mean, I think that's what he said. So I think...
That's right for a start, isn't it?
Yep.
And there are other examples, aren't there? Or have I got it wrong?
I think your Lordship is right.
Common guarantors, for example, not co-guarantors, because that would be a contract, but several guarantors, both guaranteeing the same obligation.
Yes. I think the point I'm seeking to make, and you may be right in that Lord Justice Irwin, on that particular part of 61, is going further than is entirely correct.
Okay.
I make the point, the learned friend says that the passage in Mitchell suggests that 7.3, or indicates that 7.3 was passed for the purpose of dealing with the rights referred to in his example. Whereas that's not right, because he's talking about examples.
Yeah.
So I just make that point in passing. But so there will be other things that are covered. So I don't go as far as say that there are no other things that are covered. But the natural meaning of 7.3, particularly in a statute which expressly covers in 1.6 and elsewhere rights under private international law, it would be very odd if it didn't cover foreign law rights.
Unless you start from the proposition that an English statute's about things to which English law applies.
Yes, but given that
and that's the circular nature of the argument that we've got.
Well, I understand that, but I think what is important is that the statute does in fact refer in terms in several occasions, and obviously the draftsman, if not the Law Commission, for some reason, had in mind foreign law, the application of private international law.
Yes.
It's in that context that it would be very surprising if you had to give a restrictive meaning to any right, which is not justified by the wording. That's the problem, I think. I think Lord Justice Phillips at 74 in that context, and in agreement with, I think I've read this to your Lordships, just focusing on 7.3, he wraps up 7.3. He runs together 1.6 and 7.3, not merely because of 1.6 and then it's H, but also because the rights of contribution superseded by 7.3 must be taken in the context of provisions which fully recognise, this is the point I was making to your Lordship, the relevance of private national law to include rights of contribution under the otherwise applicable foreign law. The creation, and I've read that to you. Can we just deal with David Richards, who deals with this at 94 to 95. On page 109, so he's already decided the case in my favour on 1.6 and doesn't like 7.3. At 94, he says Mr. Hollander placed greatest stress on 7.3, where literally it was capable on its own of excluding in proceedings brought in England and Wales contribution claims governed by foreign law. Mr. Hollander at first went further. It would serve no purpose if it didn't exclude contribution claims governed by foreign law. That's my Lord's point. In the course of argument, he retreated somewhat from that position, accepting rightly there were various rights of contribution in common law and equity which were superseded by 7.3. In my judgment, the answer to the issue on this is not to be found in 7.3. If on analysis of the remaining provisions of the 78 Act it were found it didn't have extraterritorial effect, 7.3 couldn't produce a different conclusion. It's consistent with either conclusion. If it didn't have extraterritorial effect, it would still have the effect of excluding other rights of contribution under domestic law. If it does, it is probably construed as excluding contribution claims governed by foreign law. It makes no sense to be concurrent and inconsistent contribution claims in English proceedings and under foreign law. Well, I would respectfully submit that is not really very fair about 7.3, really particularly for the reasons given by Lord Justice Phillips. That actually, the point I've just made to your Lordships, that you've already got these. So Lord, those are the relevant sections of the statute, and rather ahead of schedule, unless there are further matters that I can assist your Lordships with, those are my submissions.
Well, there's never any need to apologise for brevity, Mr. Hollander. Thank you very much. Mr. Doherty.
rather ahead of expected schedule. Lord, my learned friend accepted the presumption in relation to overriding effect, but then on a number of occasions made the point that or fell into the trap that we say that Lord Justice Irwin fell into, which is to say, well, why wasn't it made clear that the Act didn't apply or should apply subject to the applicable law? Well, with respect, that's to get it the wrong way round. The effect of the presumption, if it is to have any effect, is clearly to underline that the position is the other way round. If you want to show that an Act has overriding effect, you should find something positive in the wording, most clearly by express wording or by complying with the various bases set out in the judgment of Lord Sumption in Cox. My learned friend dealt dismissively with the Law Commission report on the basis that it didn't really assist on the relevant questions, but with respect, for the reasons I hopefully showed your lordship, it does. It identifies the mischief to which the Act was aimed and therefore the purpose that the Act sought to serve. None of that included any issue of overriding effect. And indeed, in relation to 7.3, one has there the genesis of the clause put forward by the promoter. And there it is quite expressly said to deal with common law rights, so quite contrary to the submission that my learned friend seeks to make. My Lord, in relation to the Bernati and the Capitan Georges, my learned friend sought to continue the nodding Homer's point. And I won't repeat the submissions that I've made, and they're in the written case, but I will just emphasise this glaring omission from my learned friend's submissions when it comes to this. To be a good point, he has to show that the relevant applicable law would not have allowed contribution.
Does he?
Yes, Lord, because in the strikeout case, the argument was that there was no case to be put. In the jurisdiction case, the issue would be, is there in fact a basis for service out? Now, if there is in fact an applicable foreign law of contribution, and that foreign law of contribution differs, but in fact gives you some form of contribution, you will inevitably survive a strikeout or a jurisdiction dispute. Turned out the other way round, my learned friend sought to rely on the point, well, the court didn't deal with a preliminary question. Indeed, it's the point that Mr. Justice Chadwick made in the Hashim case. None of those cases identified a preliminary choice of law question. But again, with respect, it ignores the fact that you only raise the question of choice of law if it makes a difference. There is no question for the court to deal with a preliminary choice of law question unless it's run. In those cases, what we do know is it was not run, and so it was not surprising that Mr. Justice Hobhouse and Mr. Justice Hurst did not deal with any preliminary question.
But these were debates, weren't they, about the ambit of the 1978 Act?
Yes.
I think what Mr. Hollander is saying, I shan't do it justice, but I think what he's saying is that if the 1978 Act couldn't apply anyway, because you have an antecedent choice of law question, you would expect someone to say so.
Well, you'd only expect someone to say so if it made a difference. So there's no point saying, well, that in fact, all this is subject to Indonesian law, which I think is based on a Dutch law system, and under Indonesian law, there is in fact a law of contribution, but it shouldn't be the 1978 Act. There'd be no purpose at all running such an argument as a strikeout or a jurisdiction dispute. This is, in a way, the fundamental point about how choice of law cases are run, jurisdiction cases are run. You run the points that make a difference. And nothing that my learned friend has identified suggests that it would have made the slightest bit of difference. And my test for that is really the reverse of the point that my learned friend seeks to make about the distinguished panellists. If they had thought it would be helpful, it is extraordinary that they wouldn't have taken up the point set out clearly in Dicey and Morris at the time, and indeed in Cheshire and North, and indeed if they dug any further into the Law Commission reports. So if there's any inference to be drawn from it is that there was no point to be taken, and there's certainly no evidence or material in those cases to tell you that there was the relevant applicable law would have resulted in a contribution, in a law where there was no contribution claim. Lord, in relation to the Baltic flame, I'm not sure if there was a misunderstanding, and perhaps there was. I may have expressed myself poorly. The references that I gave your lordships in relation to the Baltic flame and the relevant laws that applied were the two sides of the triangle. I was not seeking to suggest that there was any direct relationship between the contribution defendants. The point that emerges from paragraph 8 and paragraph 40 is that both of those sides of the triangle were subject to English law. Now, that provides a very strong starting point that the relevant law for the contribution would have been English law. Indeed, if it was Rome II, that would be the answer under Article 20. Under English law, there may have been more argument. But the one thing that is entirely lacking from the Baltic flame is any suggestion that any of the relevant legal relationships were subject to Saudi law. The point that was simply being made, if this case ends up going to Saudi Arabia, that jurisdiction will not apply contribution. Entirely separate question. And Lord, in relation to the passage that my learned friend took you to of Lord Justice Potter, I think it's paragraph 35 or 36 on page 515. Leaving aside the more general points about the scope of what Lord Justice Potter was referring to, and this, of course, was a jurisdiction dispute, this aspect of the case was entirely about the proper forum and the discretionary questions as to whether this should be heard in England or not. That's the context of everything that's being said. And where he then starts in paragraph 36 and refers to the strictly territorial scope, he says it's unequivocal in its application to all proceedings brought in England, and there is nothing in the Act or in particular section 1.6 to limit the right contribution to liabilities incurred in England and Wales. That's the point that he's making, and that's the and one knows that first because that's what he says, but also because he refers back to the judgment of Mr. Justice Hurst in the Captain Georges, where that's precisely the point. So, leaving aside the English law question, does the 1978 Act apply where the liability is incurred outside England and Wales? And the answer, unsurprisingly, is it does. And that's the answer that is being given by Lord Justice Potter. So again, there is a danger here in seeking to read words of a judgment as a statute, which is always dangerous, but it's particularly dangerous when the point hasn't been argued, isn't an issue, and doesn't matter for the result of the case. So, Lord, the Court of Appeal were entirely right not to seek to second-guess what a panel of distinguished judges and eminent practitioners might have concluded if a point, or why they didn't take a point when it suggested that they would have done if it was a good one. Lord, my learned friend referred to the Fluor decision, the Victorian case. I think I did refer to it in the Court of Appeal in my written submissions. It wasn't part of my oral argument. It's not a big point. What my learned friend didn't do was actually take you to the bits that we rely on. My learned friend is entirely right to say that Fluor was a decision which was very much affected by the federal context of Australia. But the actual aspects that we rely on are more straightforward construction points, which the judge addressed. And if I could take your lordship to page 615 of the bundle. And it's paragraph 56. So it's quite right that the judge has explained that there is a particular Australian context and how these things should be read. And of course, I should also say there's no here reference to presumption, so that pre-Cox is not being considered. But at paragraph 56, Fluor's argument that Section 23B6, that's equivalent to 1.6, of the Wrongs Act is itself a statutory provision which overrides the common law choice of rules must be rejected. The function of that provision is merely facultative. It permits a claim to be brought under Victorian law even where the underlying liability in tort, breach of contract, breach of trust or otherwise falls judicially to be determined according to the law, written or unwritten, of a jurisdiction outside Victoria. It is not difficult to imagine a situation where choice of law rules which relate to a contribution claim, whatever they might be in a particular case, would dictate the application of Victorian law, even where the wrongdoing of one or the other, or even both the parties involved, failed to be determined according to the law of another jurisdiction. And then he refers to, if one rearranged the facts of this case, you might get to that answer. So taking obviously a very different view from Lord Justice David Richards. Similarly, Fluor's argument with respect to 24.2a, sorry, this is under paragraph 57, and that's the equivalent provision on contributory negligence under 2.3c, must also be rejected. This section merely ensures that the determination by a Victorian court concerned with the contribution claim of an underlying liability according to the law of a jurisdiction other than Victoria, which recognising apportionment of damages for contributory negligence would take contributory negligence into account in determining contribution. And then gives an example, and picking it up at the end of the page, once Section 23b6 is seen as a facultative position, enabling foreign law to be applied to determine the underlying liability, where Victorian law is the appropriate law to be applied to the claim for contribution, no difficulty is encountered by applying Section 24.2a according to its terms. So, Lord, that latter part of the judgment is what we rely on. It's the analysis of the terms and the language. Now, whether it takes it much further, your lordships have obviously heard a lot of argument now, but we do say it is not only consistent, but supportive of the construction that we seek to underline. Lords, in relation to the question under Section 1.6, my learned friend repeated the invisibility point of Lord Justice David Richards. Well, hopefully I have addressed your lordships on that, and indeed one sees that Mr. Justice Buongiorno seemed to take a similar view, and we certainly say, and indeed supported, we'd say, by the extracts of Dicey and Morris, one can envisage such situations. But in a way, the more important point is the point of principle. Once you accept that that question is subject to the applicable law, Section 1.6 and the Act as a whole is subject to the applicable law, you need to provide an answer for each of the situations that arise. And to say that that somehow points you in a direction one way or another, we say it is not a good point. My Lords, in relation to Section 7.3, with respect, my learned friend misses the first point that we make in relation to Section 7.3. The first point is that the language of the Act under Section 7.3, and my Lords, just to read it out, and this is at page 258 of the bundle, the right to recover contribution in accordance with Section 1 above supersedes. So the premise is the right under Section 1 exists in the relevant case. Now, if we are right on Section 1, that it's displaced, then Section 7.3 does no more. Section 7.3 only applies when Section 1 applies. That's our preliminary point. We then go on to make the point about what rights are being referred to, which we say are referring to English rights and not naturally foreign rights. And for that, we have not only what we say would be the natural interpretation in the context of domestic statute, but helpfully the statement by the promoter when introducing this specific amendment. So whilst my learned friend is right to say that we can't explain precisely why Section 1.6 and 2.3c were introduced, we can say why Section 7.3 was introduced, because we're told by the promoter. I mean, whilst I'm on that, the consistent answer for section 1.6 being introduced and 2.3c is the one given by Mr. Justice Hurst in the Capitan Georges, namely it helps to spell out what liabilities are being referred to. And I've made this point earlier in my submissions this morning, that if one hadn't had section 1.6 or 2.3c, the courts would have had to have concluded what the scope of liabilities were, and may very well have concluded actually that liabilities should be given a proper wide meaning, which would include foreign liability. That is entirely consistent, and this is the point. Section 1.6 and 2.3c are entirely consistent with the Law Commission's report. An interpretation, however, of 1.6 and 2.3c, which seeks to suggest that they intend overriding effect, that is inconsistent with the identification of the mischief and the purpose of the enactment of the 78 Act, and finds no support in any of the commentary. Lord, unless I can be of any further assistance, those are my submissions.
Thank you very much indeed, Mr. Doherty. Well, we're grateful to all counsel and those behind them for all their assistance. It's an intriguing problem. We'll do our best to let you have a decision as soon as we can.